number 8, the people of the state of New York versus Anonymous.
Good morning, Your Honors. Catherine Pecor. Oh, excuse me.
One moment. Ms. Pecor, do you care to reserve some rebuttal time?
Yes, I would like to reserve 2 minutes for rebuttal.
Of course.
Good morning. Catherine Pecor, of counsel with the Office of the Appellate Defender on behalf of appellant. May it please the court. Your Honors, the First Department held in this case that where the sealing statute, CPL 16050, is intentionally and blatantly violated and causes obvious prejudice to a defendant, there is no remedy on direct appeal of a criminal conviction.
Going to prejudice, counsel, and I'm not sure of this in the record, but it seems there's almost an independent source argument here. I mean, did your client come into the police, I believe it was, and essentially recount the version that he gave in the trial?
So I think there's some dispute as to what was said in that meeting, and I know there was some dispute about that in the briefing in the trial court.
But I think there's a letter submission from the defense at the sentencing that essentially says that it tracked the trial testimony, right?
Well, you know, what happened here is there may be, in fact, an independent source for this
Where
evidence.
would the prejudice be?
But we don't really know. I mean, what the prosecutor would have had to do, under my reading of the sealing statute, is bring in evidence independent of the improperly unsealed transcript and use that to enhance appellant's sentence. But that's not what he did. He represented to the court that he needed this transcript to be unsealed, that without it he could not support his vigorous sentencing recommendation, and that it was critical, and that he could not the outlet hearing could not be done without this transcript. So I think it's up for debate whether the prosecution would have had sufficient evidence and witnesses to make this showing that appellant violated the conditions of his plea.
Well, this was a little bit unusual too, wasn't it? I thought in this instance that the court adjourned the sentencing to let the other trial take place, and then the other trial took place, and then subsequent to that second trial, then the sentencing took place on the first trial with the transcript in there. So under that circumstance, of course, the DA could have moved, when the court adjourned it, to unseal, to unseal it in the interest of justice, any evidence that might come in, or it could have moved afterwards. That didn't take place, did it?
Right. So there is a mechanism in the statute for when a defendant has another open case, for the DA to move on notice to the other party to stay the sealing in the first instance. But that's a different provision and a different standard than the standard that is required to unseal something that is sealed.
There was a mechanism for them to preserve their rights. They didn't do that here.
Exactly. And so in Catherine B., this court granted what was the functional equivalent of a suppression remedy.
Would you stay sealing in that instance of the entire transcript, or would you stay sealing of just a portion?
I think that would be up to the prosecutor, but the point is that didn't happen here. What happened instead was that he moved after the fact to unseal the proceeding, and the only difference between this case and Catherine B. is really the timing,
I think the difference between this case and Catherine B. is they were using or attempting to use the facts related to the arrest in Catherine B. to enhance a sentence. And here, they're attempting to use testimony as to a different crime to show that the conditions of the plea were violated and the judge's order was violated. Isn't that a big difference?
Well, a couple points here. A defendant, I don't believe a defendant waives his right to the protection of the sealing statutes by exercising his right to testify in a criminal case. But more importantly,
that's kind of a broader issue.
The statute doesn't differentiate between parts of the record that are the acquitted conduct versus parts of the record that are other things. The entire record, it's categorical, the entire record is sealed, and that's in recognition of the fact that this individual would never have been brought into court. He would never have had to testify.
I guess that raises the question, can a sentencing judge, given the authority of the sentencing judge and the fact that there has been an allegation that that sentencing judge is order has been violated, does that sentencing judge have the authority then to get material indicating a different crime has been committed that's part of the record in this case?
Well,
the subsequent case?
so I don't view that as any different from Catherine B. In Catherine B., this court's holding is very clear. It held that a prosecutor may not, under the law enforcement exception, unseal materials for the purposes of making sentencing recommendations. And not only
It's
that.
not a sentencing recommendation here. It's just, did you violate the terms of the order?
Right. The prosecutor was the one.
Look, you should get the high end of the range because you were arrested for, I think it was attempted robbery or whatever the second charge was. So we want to unseal and we want to show you engaged in these bad acts of attempted robbery, even though you were acquitted. And I think that's what Catherine B. says you can't do. But here, there's an admission of a different crime, and they want to say, look, you were out on the condition that you didn't do this, and you've admitted doing it. And can you really shield that fact from a sentencing court?
Yes, Judge, I believe that's exactly what the sealing statute does. There is no outly hearing exception to the mandate that requires these records to remain sealed. And indeed, the prosecutor was seeking this transcript to support his recommendation that appellant be sentenced to twice the promised sentence.
Can I turn you to a little bit different area, if you're done there? The appellate division relied on People v. Patterson. You're familiar with that?
Yes.
And there, the Court of Appeals did not require suppression when the police used a photograph of the defendant in a case that had been dismissed to show the robbery victim in a photo array. So here, would we have to reconsider Patterson in the light of Catherine B., or do we have to overturn it to apply the exclusionary rule or suppression?
No, Judge, this court does not have to overrule Patterson. Patterson can be reconciled with Catherine B. I think Patterson is quite distinct from this case in a couple of important respects. First of all, the sealing statute violation in Patterson was committed by a police officer. It was apparently, or may have been accidental, and there would have been no real deterrent value in suppressing the evidence of the identification because the police officer is not likely to know that the photo array is suppressed in a later trial proceeding. In this case, the violation and the prejudice to the appellant happened in the same case, and the prosecutor who requested the order unsealing these records was the one who benefited from the unsealing. And so there's the deterrent benefit.
I have your distinction. There's your time. I don't want to take all your time. There's just one issue that's bothered me. The most compelling argument here is, I think, the presumption of innocence argument. That's the most compelling public policy rationale for this rule. The other side of that, though, is that the sentencing here doesn't involve a question of guilt or innocence. It only specifically involves the range of sentencing and not any determination. So, that being the case, does the presumption of innocence argument apply in the context of sentencing?
I think it does. So the presumption of innocence is the overriding principle. I see my light has come on, but if I may answer the question.
You may.
The principle behind the sealing statute the legislature had in mind, as you point out, the presumption of innocence. The presumption of innocence doesn't narrowly go to the concept of acquittal versus conviction. The presumption of innocence, I think, refers to the overall idea that when someone is brought into court on a charge that is not successful, that is not ultimately upheld, that person is exposed to all kinds of consequences that they never would have faced if they had not been hauled to court on that charge. So I think this court should view the presumption of innocence as...
What you're saying, if I have it correctly, is that you can't use an unsuccessful evidence from an unsuccessful prosecution as evidence in a subsequent proceeding.
Exactly. Nothing stemming from that record can be used because the presumption of innocence underlies the whole proceeding. Thank you.
Counsel?
Good morning, and may it please the court, Julia Cohen for the people. Your Honors, as part of defendant's beneficial plea agreement in this case, the court mandated that he abide by 3 pre-sentence conditions and promised him that if he abided by those conditions, he would receive a sentence of 4.
What concerns me here is that if we allow this unsealing under these circumstances, don't we end up with the exception swallowing the rule? I mean, why wouldn't we allow it then in any sentencing context?
No, I don't
Or
believe so.
certainly in any sentencing context where there were preconditions? Or is that what you're saying we should be doing?
I don't believe that the exception would swallow the rule. The facts of this case are exceptional, and that's what distinguishes it from Catherine B.
Yeah, so that's my question.
What is it
What
that-
makes it exceptional? I mean, there are many, many cases where these exact, well, maybe not these exact circumstances, but where somebody is released on the condition that they not be rearrested or, get into trouble or whatever. So it's so common.
Sure. So I think one thing that makes it exceptional is that the defendant went to trial and testified while this case was still pending. Normally, you would expect to see a sentence imposed and then the trial in the subsequent case to follow. Another reason why...
To me, that makes the argument even stronger the other way because the DA here could have sought not to have it sealed in the first place. There's a standard for doing that. And didn't make that application.
Another thing that I think makes this case exceptional, Your Honor, is that after the defendant was arrested and charged with robbery, the prosecutors came into court and asked the court to vacate the plea and to allow them to proceed on the top charges of the indictment. The defense counsel asked the court to hold this case in abeyance pending the outcome of the robbery case. In other words, it was for the defendant's benefit that sentence was not imposed until after the robbery trial in this case.
Well, but the benefit was to see if he was convicted or acquitted.
Well, the benefit, I think, was to see either convicted or acquitted, or, as in this case, what came out at that trial.
Why couldn't the defendant have relied on the sealing statute in making the decision about whether to testify at the trial, at the robbery trial?
I don't think he could have relied on the stealing statute because there was no expectation that he was going to be acquitted, and if he were not acquitted, the case would never have been sealed.
Well, he may have thought he was going to be acquitted.
Another reason why...
He knew that the sealing statute was in place, and knew that if he was acquitted, that couldn't be used.
Sure. Another reason why I think it would have been unreasonable for him to rely on it is as he had already disclosed the sum and substance of his testimony to the prosecutor in this case prior to the robbery trial.
Why didn't you use that?
So we did, Your Honor. After the defendant was acquitted, the prosecutor came into court and made a sentencing recommendation of 9 years to the sentencing court in this case and represented the contents of the defendant's testimony, which you recognize was substantially similar to what he testified to on the stand.
Why did you need the unsealing order?
The judge in this case essentially requested the unsealing. The prosecutors made a sentencing recommendation, recommended that he impose a sentence.
I have then misread the record because I thought the prosecutor asked the judge, would the judge entertain a motion to unseal?
So technically, the prosecutor did move to unseal, but it was only made in response to the judges instructing the prosecutor to particularize whatever information he had about defendant's criminal conduct during the pendency of this case in writing. So
That doesn't necessarily require reference to information that's sealed, right? I think that was Judge Garcia's prior point. You've got an independent source for it. That's what you should be depending on.
So the sentencing court explained that he was not going to impose an enhanced sentence lightly and wanted more details essentially about defendant's testimony.
Yes, and then the prosecutor makes this motion and this request, and
Correct.
that's why in part we're here, because that seems to be in violation of the statute. But let me ask you a different question. It strikes me that your approach results in what I think is an anomaly that would be very difficult for the court to uphold, which is if they had sought to a civil action, if they pursued a civil action seeking to prevent the unsealing or to stay the unsealing pending an appellate determination as to the propriety of the request to unseal, they might have been successful. Certainly the appellate division below thought that there was an error, and that would prevent the unsealing. And so we wouldn't be in this place. But because defendants sought to raise the question on direct appeal, going to the error at sentencing, there is no remedy. And that strikes me as an anomaly and just unfair.
It is because the defendant did not exercise the remedy that was available to him under the law, and that would be taking a civil appeal prior to the unsealing. So it's not that there is no...
True, to prevent the unsealing, but now you've got this other injury at sentencing, right? That flows from that original error. You've now got the error of the use of that unsealed testimony to base the enhanced sentence, and that they are challenging on the direct appeal. But the appellate division says, well, you have no remedy for that. You would have had a remedy to try and stop the sealing.
I would dispute that the error flowed directly from the unsealing in this case.
Well, I'm sorry, didn't the sentencing court decide at the Oatley hearing the only reason that the sentence was not going to be as promised at the plea because he had violated the conditions by indeed this drug transaction that he admitted to on the record in the trial in his defense?
So although defendant was obviously prejudiced by his inculpatory testimony, it was not the unsealing that resulted in the prejudice. The court was aware of the contents of the testimony before the unsealing even occurred. They're just
Based on what?
based on the prosecutor's representations.
So there's
But that would not have been evidence, right?
I'm sorry?
You'd have evidence. That would not have been evidence, correct?
What-
I thought you said that's what the prosecutor needed to indeed establish, satisfy the burden of proof at the Oatley hearing.
So the court, so under Outley, the court had an obligation to ensure that it was basing its sentence on reliable and accurate information. I believe the court would have been entitled to impose the same sentence as it did in this case, prior to the unsealing, based on the prosecutor's
You mean
representation.
the prosecutor came in and said
That he told me that he was out committing a massive
that
drug.
that would have been enough?
The court could have inquired further from the defendant, but the fact is the
Did the
defendant.
prosecutor have to take the stand, cross-examine?
It's up to the court to determine the nature and extent of the inquiry.
So
under
the
Outley.
record has reference to a letter written by the defendant and sent directly to the court, but that letter does not appear in the appendix or the record. Is it part of the record in the trial court or no?
Yes, I believe it should appear. I believe it's in the appendix. It's from the defense counsel to the
No,
court.
there's a reference actually to a letter, I think that letter from defense counsel references a letter written by the defendant to the court. Do you know anything about that?
Not aware at
Okay.
this moment of the contents of that letter, no.
Okay.
So turning back to Catherine B. and the distinguishing features of Catherine B. in this case, in Catherine B., there was no plea agreement. There was no Outley hearing. And most importantly, there was no sentencing recommendation until after the unsealing, right? So Catherine B. dealt with the narrow question of whether the law enforcement exception under 160-51D2 allows a prosecutor to unseal materials for the purpose of making a sentencing recommendation.
So what exception does the unsealing here fit under, if it's not that one?
I believe it fits under that one. In addition to the CPL provision, the court under 410.4, the court was required to consider defendant's compliance with the pre-sentencing conditions. The CPL says the court shall consider whether or not defendant complied with the pre-sentence conditions.
But that doesn't speak to what proof is available to establish the violation of the.
No, it doesn't specifically speak to it, but
So, I mean, it sort of goes back to that the sealing statute doesn't provide an exception for the court's obligation to sentence based on reliable information. It's not in there.
not within the sealing statute itself, but
Right.
it does provide this sort of catch-all law enforcement agency exception that says,
But the prosecutor is not a law enforcement agency, and certainly the court is not a law enforcement agency, right?
I believe that
Under the case
the
law?
prosecutor is a law enforcement agent, yes. And I think that to the extent that Catherine B. said that for purposes of that provision, a prosecutor who's making a sentencing recommendation, I think that has to do more with an interpretation of the legislative intent in passing the statute, right?
So you don't read Catherine B. as saying that that exception doesn't apply to the DA?
No, I do not. I think that Catherine B. was dealing with a very disparate set of circumstances as we're dealing with in this case.
You're rejecting the appellate division's analysis, then?
That the law enforcement exception, I think that Catherine B. is not controlling in this
Well,
case, yes.
they say that the unsealing here did violate Catherine B., and basically this is an error without a remedy.
That was what the majority said. The concurrence, I believe, said that, that this court might find that the unsealing was justified under CPL.
If I could only get these guys to agree with me that my concurrence overrides the majority, I'd be a happier judge.
In another case. Well, Catherine B. really, at the heart, stands for the proposition that a prosecutor cannot seek to unseal, or you can't unseal the record that's been sealed under the CPLR 160.50 simply because a prosecutor wants that information for purposes of making a recommendation for sentencing. And although I know you keep arguing that's not what happened here, the whole point of the request to unseal was to have information to present to the court to show that he had violated, right, the terms of the conditions of his plea only to one end, which was to get him out from under the agreed-to sentence. To
Respectfully,
enhance that sentence, to
Respectfully-
impose a more harsh sentence.
I think respectfully, I would have to disagree. Defendant's sentence, the sentencing range to which he was exposed was determined prior to the unsealing, prior to the robbery case. Unlike in Catherine B., where the unsealing was used to come up with a sentencing recommendation, defendant here was aware that his sentence would be between 4 and 9 years.
But you yourself have argued that the judge made clear to the prosecutor that the court would deviate from the agreed sentence only if it had the kind of proof that would permit that, right? And that's why the prosecutor wanted to get to this testimony. That's why he presented this testimony. And that's what the court relied on.
If I may, Your Honor, I believe that the court was entitled and required to determine whether or not defendant complied with the terms of his plea agreement, and simply because that had a downstream effect on the length of his sentence, that does not mean that that was the sole purpose for the unsealing. Thank you.
Thank you, counsel. Counsel?
Yes, I'd just like to touch on a point that Judge Rivera brought up about the First Department's decision creating sort of an unfortunate anomaly here, which is that if someone does what the petitioners did in Catherine B. and pursues an interlocutory civil appeal and goes about it that way, they're entitled to this, what is functionally a suppression remedy, but when someone deals with the issue on direct appeal, as appellant did in this case, he's effectively out of luck. And I think that would
Doesn't
present...
that assume we would find for you on these other issues? I mean, we've never considered that in the context of what happened here, right? This is somewhat different. It is different use than Catherine B. Your argument, I understand, is it's essentially the same, but that argument you're making now assumes this court would find for you on the other issues. So it's really essentially just your suppression argument, right?
Well, I don't want to dwell too much on the issue, the other issue in front of the First Department, but my point is just really that this right under the statute is an important one, and the legislature recognized that it was an important right. And under Catherine B., we know there is a remedy, at least in some cases.
Let me ask you this. Does the CPL or our case law, would it have allowed any other procedure than this one to try and attack the use of the unsealed material for sentencing enhancement purposes? That is to say, the only mechanism by which you could attack that error, because there are two errors, right? There's the unsealing and then there's the use. I mean, if you unseal and never use it, that's one story. But here's the actual use for purposes of sentencing. Is there any, could there have been some civil action? Doesn't the CPL require this is the only way you can present this error?
I don't think it's the only way, and I don't think Catherine B. says it's the only way to present this error. In fact, it would make perfect sense for appellants, defendants to be able to bring this issue on direct appeal of a criminal conviction. They're not entitled to counsel on a civil appeal, an interlocutory civil appeal. It's a situation where, in the interest of judicial economy and efficiency, we would want to encourage defendants to preserve this issue just like any other trial or sentencing issue in the lower court.
Counsel, just one final question. Are you familiar with the Commission on Judicial Conduct versus Rubenstein?
Yes.
So talk me through that. How do
So
you distinguish
that's a case where this court found that I believe it was the Commission on Judicial Misconduct had a statutory obligation to conduct investigations in the public interest to determine whether attorneys or judges have engaged in misconduct, and that empowered the court to access records to which they were otherwise not permitted access. And so here, we don't have an equivalent statutory mandate that has that broad catch-all kind of public interest investigatory function. And the court in Rubenstein also limited unsealing in these cases to instances where there are extraordinary circumstances and where the mandate would be impossible to fulfill without the unsealed materials. And neither one of those circumstances are present in this case.
Thank you.